Oh, sorry, I was muted. Yes, that's one moment.
Thank you.
We're recording.
Okay, thank you very much. Good morning. The Appellate Court for the State of Connecticut is out of recess, open and in session for the third hearing of the morning, Tuesday, April 13th, 2021. This is the 11:30 appeal, ORZECH v. GIACCO Oil. I apologize if I mispronounced. I would ask that everyone participating in the hearing introduce themselves, starting with the judges, then counsel for the appellant, and then counsel for the appellate. I am Judge Alborn.
Good morning, I'm Judge Mall.
Good morning, I'm Justice Norcutt.
Nicholas Varunas for the appellant, GIACCO Oil.
And Andrew Wallace for the claimant, Stanley ORZECH, by his wife, Barbara ORZECH.
Okay, thank you. Counsel, you've received procedural instructions with respect to these arguments over the Teams platform. Do you have any questions?
No, Your Honor.
No, Your Honor.
Okay. I would just say that if by chance anyone gets bounced out of the hearing, no problem. We will pause the timing, pause discussing, and certainly exit and then come back in. And usually that does work. We are live streaming this hearing. If the matter does include any protected information, please be conscious of that and do not disclose the statutorily protected information. Attorney Varunas, would you like to reserve any time for rebuttal?
Yes, Your Honor, I'd like to reserve 2 minutes for rebuttal.
2 minutes, okay. So I will put 18 minutes on the clock and you can begin.
Your Honors, this appeal stems primarily from a number of errors in the application of the facts to the law in this case. The trial commissioner and subsequently the CRB did not apply the appropriate analysis to a second injury which occurred, and that injury would have been the death of Mr. ORZECH. They did not apply the natural and direct analysis which was mentioned and held in the SAPCO versus State case, which is cited extensively in my brief, but they seem to rely primarily on approximate cause, simple analysis, which is applied to the initial injuries. The other error, which is particularly important, is that the trial commissioner and the CRB seem to have not confused, but merged the cause of death with the manner of death as ascribed by the medical examiner. And in this case, the cause of death was the intoxication as a result and the combined result of drugs and alcohol causing a respiratory distress and slowdown. The manner of death was attributed by the medical examiner after only receiving the coroner's report and the police report as suicide. The cause of death was the combination of drugs and alcohol. The alcohol was a substantial factor in the cause of death and thus is an absolute fact in this case. The trial commissioner dismissed that fact, set it aside, and determined that Mr. ORZECH committed suicide as a result of falling down a number of months beforehand and suffering some injuries. The manner of death in this case is also speculative. And I recently submitted a case called Galinsky versus Beaver Tree Services, which is a CRB decision, which affirms once again that speculation is not allowed by the CRB or the trial commissioners when determining liability, particularly in a medical report. It is a CRB decision, and they do cite two prior decisions, but it's telling that in a case where none of the expert witnesses met the claimant, none of the expert witnesses had full access to all the information when they came to their conclusion, and yet they speculated that Mr. ORZECH committed suicide because he was severely depressed. therefore, the application of that speculation and the failure to follow this precedent set forth by the CRB resulted in an error. And what's truly erroneous about the analysis that the trial commissioner performed and was affirmed by the CRB was once again this alcohol. In SAPCO, the Supreme Court stated that when a person has an initial injury, the causal analysis is proximate cause analysis and substantial factors leaning towards the humanitarian purpose of the Workers' Compensation Act would be to find for the claimant, or to lean towards finding for the claimant. The subsequent injury in its analysis was that afterwards you would use a direct and natural analysis. And in that case, in SAPCO, the primary focus was on the fact that there may have been an intervening superseding event that had recently been abrogated by the courts in jury trials. So that question arose, and that intervening superseding cause analysis was not abrogated for workers' compensation cases. So using the direct and natural analysis, you were allowed to look at all the events leading up to the second injury when trying to connect it to the initial compensable injury. And that analysis allows for the inclusion of intervening actions. In this case, we have an intervening action, which is the excessive amount of alcohol, which combined with the drugs resulted in the death of Mr. ORZECH. Now, there was evidence that the alcohol by itself would not result in the death, but there was no evidence that the drugs would result in the death by themselves. So the absolute fact and the absolute cause of death was the combined effects of alcohol and drugs. Therefore, the action of drinking has to be included in the causal analysis. And the trial commissioner failed to do that by setting it aside, saying it was something he did. In fact, the plaintiff's expert did the same thing. They seemed to rely on the fact that Mr. ORZECH was not an alcoholic, and there was no evidence to that effect, and that was not part of the defense. It was that he committed an act which intervened between the taking of the pills and the fall, that caused his death. Now, the evidence shows that he drank at least 8 alcoholic beverages within an hour of dying, an excessive amount of alcohol. There's no evidence that he did so with the intent to die. There was no evidence that he did so with that this would be part of the suicide. He did not do this with any intent to cause himself harm, but he did do it voluntarily and intentionally because he did consume the alcohol. And he did do that even though alcohol and the drugs he was taking were contraindicated by his medical providers, and his wife testified that he understood that they were contraindicated. His wife also testified that he had control of his drugs and that he knew how to take them. So the fact that he went and consumed this large amount of alcohol and then eventually consumed the pills resulted in his death. This alcohol is a major factor that must be assessed. Now, using the SAPCO analysis and their reliance on Professor Larson's treatise, the analysis is if between the initial injury and the subsequent injury, the claimant or the plaintiff does something voluntary, which breaks the chain of causation, then it's a superseding intervening event. And in that analysis, they use the hand injury, a person having a hand injury and then having a boxing match. And I cited that in the brief. In this case, we have a man who slipped and fell, hurt his knees, his back, and his shoulder. It was an accepted injury. He was allowed to go for treatment. He did go for treatment. He was allowed to have pain management treatment. He was not prescribed any drugs as a result of the injury. All the drugs that were involved in this case were unrelated to the claim. None of them were played by the respondent. There was no evidence that they were accepted by this respondent. So he has these unrelated drugs that he's getting. He goes out after trial, before a decision is rendered, and drinks an excessive amount of alcohol, and then sometime later takes a number of pills and commits suicide. The causal connection, the act of drinking this alcohol is a superseding intervening event because he voluntarily did something in contradiction to what he was supposed to do, and it eventually resulted in his death. The trial commissioner did not accept that.
Attorney Veronis, can I interrupt you with the question? I'm sorry to interrupt, but do I assume correctly that since SAPCO came out, I guess in 2012, there have been no appellate cases in the workers' comp setting dealing with a subsequent injury, the subsequent injury being death by suicide?
I'm not aware of any cases, Your Honor, or cases that involve that analysis.
All right, thank you.
Further, and into the more recent case that I had cited and sent in the Galinsky trial, the other error that was resulted from the commission and the CRB was that they relied on a speculative medical report when determining liability. The expert opinions in this case both indicated that there would not be enough evidence to be certain of whether Mr. ORZECH committed suicide. Now, Dr. Waynick said to a reasonable degree of medical probability that he believed that this was. Dr. Seelig, the defendant's expert, stated there's no way to know. Now, on cross-examination and during his testimony, Dr. Waynick did state that there's no way to be certain. He also admitted to not knowing a certain number of facts. He had never met Mr. ORZECH. He was only provided information from the medical providers, and he relied primarily on the medical examiner's report. Now, also Dr. Huang, who was the primary care physician who wrote a letter after being asked by the claimant's wife regarding causation, indicated he believed that Mr. ORZECH was depressed and that he suffered from depression and committed suicide. Yet he had never met him, he had never treated him, and he had never, and he had only relied on notes from his predecessor, Dr. Tominelli. Dr. Tominelli's only note indicating depression is a note which says depression, and he prescribes an ineffective dose of Zoloft. Both doctors indicate the Zoloft is ineffective. Now, admitting all that, Dr. Waynick still says that his opinion was that Mr. ORZECH committed suicide. And yet, yes.
Counselor, can I interrupt you for just a second? How many pills, was there medical testimony as to how many pills were ingested?
Yes, Your Honor. At the deposition of the medical examiner, she could confirm based on the blood testing and this tissue testing that there were 17 pills absorbed in the body. Yet the testimony also stated that there were more in the stomach contents that had yet to be absorbed. So it's indeterminate, other than the count that she was able to extrapolate of 17 pills, that how many pills he actually ingested. What were absorbed in the bloodstream was the 17 pills that made up of 4 different medicines.
So there was no medical testimony that the pills in and of themselves would have led to suicide?
Correct, Your Honor.
And the 4 different medicines included the Zoloft, or it was the...
Yes. I'm sorry, Your Honor. Go ahead.
ahead.
There was Zoloft, but Zoloft would not have caused the respiratory failure that Mr. ORZECH suffered. It did enhance the other effects, but the primary effect was caused by Ativan or lorazepam, which was a medication that Mr. ORZECH had been prescribed for approximately 18 years prior, or from 2012, prior, and he had. And then he also took Lunesta, which was a sleeping pill, and a decongestant. Those three pills combined with the alcohol caused a respiratory failure. Those three medicines taken in conjunction. He also did take some Zoloft, and the Zoloft apparently enhanced some of the properties of the other pills. But in and of himself, the Zoloft, which was the only depression medicine he had from Dr. Tominelli that we were based on a diagnosis of depression, if you could call it that, was the Zoloft. Once again, the depression had not been claimed as a workers' compensation, so none of those pills had been provided by the respondent or the respondent carrier. So when he took those pills, he had somehow, after losing his insurance, been able to access a significant number of pills, because there were a lot of pills around his body when they found him. And therefore, he had control of them. And what Dr. Wainick said is that all this information, including the information that he received from the plaintiff or the claimant's wife, leads him to believe that Mr. ORZECH committed suicide. But without anything further, there's no way to determine that he in fact intended to commit suicide. There's no note, there's no diagnosis of severe depression. There was no follow-up from his primary care physician after that prescription for Zoloft. He was prescribed 5 milligrams of Zoloft, which both Dr. Seelig and Dr. Wainick indicated were ineffective for treatment of depression. He subsequently went for pain management, and there was no mention of depression or the Zoloft in the pain management records. He subsequently went for further treatment. He saw Dr. Strugar for a back, referred him to Dr. Johar, who was a pain management physician. Dr. Johar was to do an injection. During that time, he was planning on doing the injection. They did a urinalysis and found that Mr. ORZECH had a high metabolite of THC or marijuana in his system. That is not relevant to the death, but it is relevant to Dr. Wainick's assertion that Mr. ORZECH was hopeless. Dr. Johar told Mr. ORZECH that he needed to stop smoking marijuana so that he could do the pain injections. And within a few weeks, he had sufficiently stopped and lowered his THC metabolites to the point where he could receive that injection. That showed that he was looking forward to getting some type of treatment and was working to get treatment, which is the opposite of the hopelessness that Dr. Wainick had continued to state in his testimony was the reason why he committed suicide, that he was hopeless and he did not know how the future was going to be. And yet, with all the contradictory evidence that he was provided and in his final testimony saying that there's no way to be certain, the result was that the expert testimony and the expert report is purely speculative. And the CRB affirms in December of 2020 that speculative treatment, and I don't want to misquote it, but this board has previously observed that in order to sustain a legal conclusion of liability, a medical opinion must be definite and positive and not merely speculative or likely. And it goes on to cite 2 CRB decisions from the past. Now, if that's in fact the case, there's no way the commissioner could rely on Dr. Wainick's report or any expert opinion in this case as to the cause of death, because they would all, as to the manner of death, because they would be speculative. As to the cause of death was scientifically based on tissue analysis, 3 blood samples to show the amount of alcohol and the amount of drugs in his system. The absolute fact was
You
that,
have run out of your first 18 minutes, Attorney Brunis.
okay, thank you, Your Honor.
Okay. Attorney Wallace? You're muted.
Thank you for letting me know. That would have been, that would have been
You do
bad.
that all the time.
So the respondents' arguments are centered upon the theme that the connection between the work accident and then the subsequent psychological condition and then the suicide are too attenuated. However, it's the claimant's position that this is the responsibility of the trier of fact when there's a conflict in evidence, and that's exactly what we have here. We have experts that were relied upon by the commissioner that made statements within a reasonable degree of medical probability. We had fact witnesses that corroborated the depression. And really, you know, you have to start with, was there enough evidence for the compensable injury? The answer is yes. There's enough evidence for the knee replacement surgery. Is there enough evidence for the depression? Yes. And then from there, what happened? He committed suicide. It was almost uncontroverted that it was suicide. And
Attorney
really,
Wallace, I have
yeah.
a quick question when you're talking about evidence. On pages 2, 6, 9, 12, and 13, and sometimes multiple times, you state that the decedent ingested 200 plus pills. I scoured the record and I couldn't find support for your statement. Where is that number in the record?
Okay, so it came from the police report, which was in evidence. The police report had.
Can you just give me the appendix site? Because I must have missed it.
Yeah, it was not in my appendix, Your Honor, but it is in
It's
the.
what?
Sorry, it is not included in my appendix, Your Honor. It is in the evidence that the commissioner had when he was making his determination.
So, well, why don't we go there? Where did the commissioner make a finding of 200 plus pills?
He said a shockingly high number of pills.
So is there nowhere that I will find that number?
There is nowhere.
You mentioned it 6 times.
Yeah, so Dr. Selig in his report is really the one that did all the math. And Dr. Selig's report is in evidence as well. And that's really where I pulled that number. Dr. Selig.
Okay, so where is that in the appendix? I must have missed it. It's a huge number. I'm just having trouble getting my head around swallowing more than 200 pills.
Yeah.
When you've drunk 4 shots, 4 beers, and but I mean, obviously I'm a smaller person and maybe the alcohol would affect. Where is that number in this appendix that you gave me?
It is in Attorney Barunis's appendix, I believe, but it's not in my appendix.
Okay, just give me the page. That's fine.
I'm sorry, Your Honor.
Well, it's okay. It must not be readily available. So go ahead. I don't want you to take all your time for that.
Yeah, I'm sorry about that. I didn't have it on me and we're remote and I apologize. But Dr. Selig, in his report, he does talk about there was lorazepam, there was meloxicam, there was Lunesta, and the lorazepam, the way he came up with that number, I'm not sure if this is what you were looking for, is he said that there were 270 pills. And then he said there were 74 that he reasonably could have taken from the day it was filled. That left 196 pills. And so that would be about 106 pills left of that prescription. The meloxicam, he said there was about 50 pills, and the Lunesta 25 pills. So that's how we came up with the over 200 pills.
That he took that night.
Well, that's the claim. The claim is that there were this man.
Well,
this
actually,
man
it's a statement in your brief 6 times. It's not a claim. It's just a little bit of a cautionary. It's a
apologize.
huge number.
Yeah, and that is the truth. But kind of looking at this, it doesn't matter how many pills he took. It doesn't matter if he put a gun to his head. It doesn't matter if he fell down. This poor man was so depressed from the work injury, and he committed suicide. So the commissioner made a determination based on the evidence that was there. And the evidence is we had orthopedic surgeons who testified about his knee replacement and that scenario. And the commissioner relied on that. And for the first time in this man's life, he goes to his primary care physician a month after his injury and gets prescribed an antidepressant. And then unfortunately, his primary care physician dies in a plane crash a couple months later, so he wasn't available to testify. But then after that, the poor guy, there was testimony from fact witnesses that corroborated the depression and sitting around in a recliner saying this is no life, going up and down the stairs on his rear end. So the depression, I feel like, is corroborated by all the fact witnesses and then is supported by Dr. Wainick's opinion, which the commissioner finds credible. So now we have a compensable depression, and this guy committed suicide. And Dr. Wainick's opinion, stated within a reasonable degree of medical probability, indicates that he committed suicide because of his compensable depression. So that's really what we're looking at this hearing today, at this virtual hearing, is whether or not the commissioner could have reasonably found the facts he found with the evidence before him. And the answer is yes, and he did, and he credited our opinion, and the commissioner is entitled to credit whichever expert opinion he feels is reasonable. And unlike that Galinsky case, in this case, the doctor's opinions were stated within a reasonable degree of medical probability. He is an expert in the field, and kind of by Attorney Varous's logic, there should be no suicide cases at all, because it would be really difficult to have anybody review records and have expert testimony in a suicide case, because you don't know the person's going to commit suicide, because if you did, you'd prevent it. So that would make it that would be an unfair burden on the plaintiffs. And suicide cases have been around for many years in the workers' compensation forum. So in this case, it's a suicide. It's not an accidental death as in SAPCO. And in a lot of these suicide cases, really, it falls on the facts, and it falls on the credibility of the expert witnesses. And, when I was reading them, they go back and forth. And really, it fell on whether or not the commissioner felt one expert was credible over another. And this is factually distinguishable from some of the other cases Attorney Varonis was talking about SAPCO, because we have a suicide here, and that was an accidental death. And also the commissioner did not credit the expert testimony in that case. And then in Galinsky, again, that medical provider couldn't state within a reasonable degree of medical probability, and here the physician did. And we had corroborated evidence even medically. We had we did the deposition of the primary care physician, Dr. Hong, who corroborated Dr. Wainick's position. So it wasn't just one thing. As far as the suicide, between the medical examiner's report, Dr. Wainick's opinions, Dr. Hong's opinions, the death certificate, all of those corroborate the suicide. It is, it's an unfortunate fact in this case. We wish it never happened, but unfortunately, this poor man felt there was no way out because he was in so much pain. He had no health insurance, and the facts showed the commissioner that it was related to the compensable work-related injury.
So the quantity of medication in subparagraph G of page 12 of the trial commissioner's findings, that would be the 200 plus pills?
Correct. A shockingly high number of pills.
No, wait. No, I'm reading 9G as in good. The phrase quantity of medication, that's the 200 plus pills that you were referring to in your brief?
Yes, that, and Dr. Selig in his report indicates the pill count as well as the police report, and both of those reports are in evidence.
And that was him taking 200 plus pills as the
Correct.
quantity of medication that he took.
That's what the math works out to when you add up the pills that were missing and the pills that were still in the bottles that the police
Okay, I
found.
just wanted quantities an amorphous number. So, but you're saying that's 200 plus pills. Okay, thank you.
Thank you, Your Honor.
Counselor, let me ask you a question. Your opponent suggests a hypothetical of the boxing match. Very, very interesting hypothetical. How do you argue against that in this case?
Could you clarify, Your Honor?
Well, he posits in his brief, and he said in his argument, there's this hypothetical of a boxing match, a person who, injures his fist, then goes out and gets in a boxing match. Isn't there some analogy here to that situation?
What I would say to that is that I do workers' comp. It is not uncommon for depression to arise from a work-related injury. It happens all the time, and it is uncommon to have a suicide. That's for sure. And it's unfortunate that this is what happened in this case. But the evidence that was presented at the trial court level at the formal hearing process supports the claim that the commissioner ultimately found. And as far as a boxing match, I'm not sure I quite understand the reference, but as far as the claimant had a burden to show causation, and we did that with evidence through fact witnesses and also expert testimony.
Does every situation of suicide, of depression that results in suicide, does it automatically relate back to the compensable injury?
Well, no, SAPCO tells us no,
Right.
And I feel like in this situation, the difference really is that was an accidental overdose. This is a suicide. In that case, the commissioner did not credit the medical opinions. And in this case, the commissioner did credit our medical opinions. So, and when you read, the trier of fact is really the one responsible for finding the truth amidst conflicting claims and evidence. And that's really the guts of this claim, is that the trier of fact had all this evidence. He had the testimony of Dr. DeJoseph and the testimony of Dr. Wainick and Dr. Selig. He didn't find the other doctors credible. He found Dr. Wainick credible. Ultimately, that's why he found the claim compensable, is because he had to sift through all the different facts. The arguments that the respondent's making are not new arguments. These are arguments that have been brought up all along the way. The commissioner had all this information, and made a determination based on the evidence in front of them. And really, as the fact finder, that was their job.
Thank you.
Thank you, Your Honor. Any more questions, Your Honor?
I don't see any, Attorney Wallace, but you can continue with your argument, or it's completely up to you. You have 7 minutes left.
Well, I would just like to point out a couple facts in this case. Is that Mr. ORZECH was a hardworking man, strong man, and this was completely outside of his norm. He worked for many years with a bad knee, and this unfortunately tossed him over the edge. He's going up and down the stairs on his rear end. He's sitting in a recliner, and he's doing nothing. That sounds like a depressed man, and that's the testimony that was presented. Dr. Wainick had all of the transcripts, contrary to what Attorney Verona said earlier. Dr. Wainick made a determination based on all of the evidence before him, the medical evidence, the transcripts from all of the various testimony and formal hearings, and that's how he came up with his conclusion. And really, in this scenario, the question just comes down to whether or not it's reasonable for the commissioner to have concluded that the knee claim was compensable, that the claimant was depressed as a result, and that the suicide was a result of the compensable depression. And that's really what happened in this claim.
Okay. You're all set?
That's it, Your Honor.
Thank you.
Thank you
Yeah.
so much.
Okay, thank you. Attorney Vrunas, you have 2 minutes, and I just have a quick question. Are you disputing the compensability of the finding that the knee claim was compensable?
No, Your Honor, that was not in dispute.
Okay.
That was open. In fact, the injuries, except for surgery to the knee, were accepted. And so he was afforded treatment for the orthopedic injuries and the pain resulting from them. And in fact, that he did take advantage of that briefly, as evidenced by Dr. Johar. Your Honor, in response to your question regarding the number of pills, the number of pills that plaintiff has noted and Dr. Waynick has extrapolated from the usage is based on Mr. ORZECH taking the pills as directed, no one else touching them, not taking a double dose someday, and all the pills being found that were on the floor. The only definitive number of pills was the ones extrapolated by the medical examiner. In her deposition, she did the math for us based on the contents of the blood and the stomach. And she did admit that there were more pills in the body, but there would be no way to know how many pills were in his stomach at that time because of the mixed contents. The same is with the more alcohol that was found in the stomach contents that was not absorbed in the blood. So to determine the number of pills, one must rely on the scientific evidence, and that would be approximately 17 based on the extrapolation from the medical examiner. Going to Justice Norcott's question regarding the analogy, the facts as they are may be reasonable, but they, when applied to the law that's required in a subsequent injury case, which is the direct and natural subsection of proximate cause, you have to take into account that there may have been an intervening event, not necessarily in the initial injury, but the subsequent injury. And I think the trial commissioner and the CRB both misconstrued that analysis by not taking all the absolute facts, particularly a substantial factor in the cause of his death, which was the combination of alcohol and drugs, and not significantly analyzing the effect that drinking that night had. That's the analysis that needed to be done in this case, and that's where the error of law and the application of the facts as they may be applied to the law. That's why there is an opportunity to overturn this decision. Now, going to the Galinsky case.
Your time is up, Attorney Vrunas.
All right. Thank you, Your Honor.
Okay. Thank you, both counsel, and we will all leave the argument room. Thank you very much.
Thank you, Your Honors.
Thank you, Your Honors.
Thank you.